Hello and welcome to the LLG vlog. I'm Helen Bennett, LLG's Executive Director of Policy and Governance, and I'm joined by our Bulletin Editor, Dennis Hall. Hello, Dennis.
Good morning, Helen.
So what have we got for discussion today?
Well, I think this is a topic that will be of interest to you, knowing you from the discussions that we've had over recent weeks. We go back today to Bulletin 4 for the Prime Minister's announcement of changes to the judicial review process. I was quite surprised by this announcement because I didn't expect what we might see as a progressive government talking about changes to the law that might be considered involving a reduction in individual and citizens' rights. But anyway, they have a justification for this. They say that their proposals are designed to facilitate the government's dash for growth by means of new infrastructure projects. This is all in the news. We're talking about the major projects, that involve various things, not least the Heathrow extension, the building of major infrastructure, nuclear plant, and so forth. But as I say, I begin with the point that this is an extraordinary position for a Labour government to adopt, given their positions on climate change and on environment and meeting net zero targets. So I think there's a quandary here in the legal profession about what this really is about and what is motivating this. And many will ask how the government can reconcile all of these positions. And as I say, the recent announcement of government support for a third runway for Heathrow means that these proposals for changes to the judicial review process remain front and centre of the news headlines, as indeed they were over this weekend. So I think the first thing we should look at together, Helen, is, well, what has the government announced and why?
Yeah, well, I mean, my understanding is it wants to reduce the number of permission stages against development consent orders, as you've just indicated, for large infrastructure projects. I think the government plans to scrap the current first attempt. Obviously, we know that as the paper permission stage. And I think they've announced that primary legislation will also be changed so that where a judge in an oral hearing at the High Court deems the case totally without merit, it won't be possible to ask the Court of Appeal to reconsider.
Yeah, it's interesting, isn't it? Because we'll come on to what some of the critics have said about this. But this means that these cases will now go straight to a hearing, therefore involving more costs and more engagement in the courts. I don't quite understand this, But when I looked at the statistics on this, I was quite surprised. Some 58% of all recent decisions on major infrastructure have been challenged in court. And the government have highlighted this as a point in their case for these changes. Each legal challenge on average takes around 18 months to be resolved. And the courts apparently spent over 10,000 working days handling these cases. Cases, they say, the government say, got nowhere. They were just what they think are blocking cases. But you're right. What is proposed, to be clear, is that they're going to remove the paper permission stage entirely, and the concern is it will be left with just that oral hearing. Now, judges will now have the power to deem that a case is totally without merit. What do you think about that? This is something entirely new.
Well, I mean, it's not the first time we've been here with proposals to judicial review, is it? Yes. I mean, there was a previous review. I think it was back in 2020, when
the Banner review.
Yeah, the then Conservative government, and it was very well publicised in the press as well at the time, and received international attention. Actually, they published a call for evidence. Basically, that probably went a bit further because it asked the question whether judicial review strike the right balance between enabling citizens to challenge the lawfulness of government action and allowing the executive and local authorities to carry on the business of government. But it did seek to curtail it quite significantly, Dennis.
Well, indeed. And Lord Banner is well behind these proposals. He said, and he's quoted as saying, "In the course of my review, I saw broad consensus from claimants to scheme promoters that a quicker system of justice would be in their interest, provided that cases can still be tried fairly." But here's the conundrum with this. So this will bring more cases towards a full oral hearing. in a court system that we've mentioned previously, haven't we, in vlogs and in the bulletin, the current court system is already, talk of blocks, it is blocked, isn't it?
Yeah.
We hear of all of the problems of lack of resources. So I don't understand the contradictions in this announcement. I've already mentioned the contradiction in relation to the government's support for climate change initiatives, net zero, and so forth. But here's another conflict, if you like. They're putting, in a sense, more court time on the back of a system that is already overloaded. I just don't get this.
No, I think it's important. I think it's important just to reiterate LLG's view in relation to judicial review.
Mm-hmm.
It was its view in 2020, and it remains its view now, which is that judicial review very much enables local authority lawyers to give effective advice to clients, and it provides a focus on communities to ensure accountability, effective consultation, and of course equalities impacts. And it's an important safeguard and provides a fundamental access to justice. And in that sense, then, it necessarily improves decision-making, transparency, and accountability, things that we talk about all the time. Now, it's not clear to me the extent to which these proposals might interfere with that. But I think your fundamental point about moving straight to an oral hearing does seem counterproductive to what they might be trying to achieve.
Yeah, the other thing I'm uncomfortable with, quite frankly, with this. Do you think that people who go to the law involving the costs that we know that it does, do you think they are always or often or mainly motivated by the desire to block or be a nuisance, just a nuisance? It seems to me there are people often more often than not, with legitimate claims where they feel their voice isn't heard. And particularly in major planning cases, they feel that the system has not assisted them with the problems that they see with major developments. Why shouldn't they have the opportunity for their voice to be heard before a judge? Because let's be clear, with all of these proposals, they amount to one thing. The latest proposals amount to a reduction in the rights of the citizen to challenge decisions of public authorities, it seems to me. What do you think of that?
Well, I think that's an important point, because when we talk about major infrastructure projects, we need to remember that this could be in relation to nuclear plants, wind farms, big train infrastructure, things that actually do impact the localities of which they are, and the people who reside there. But the government sees it different, doesn't it? It says that it wants to end the challenge culture by taking on the NIMBYs, and what it refers to as a broken system that slowed down progress as a nation. They're bold words, aren't they?
Yeah, I think NIMBYism could be an unfair sense of the type of people who bring or get involved in group situations to take litigation of this kind. I'm not entirely comfortable with the arguments that have been put forward. And indeed, when we look at some of the things that the critics say, the Law Society do not agree with what is being suggested. They reflect some of the points that we've made. They've also raised the question of there should be an analysis of the cost implications before committing to these reforms and removing the paper application stage. They say specifically, the Law Society, that they do not consider that introducing a specialist, nationally significant infrastructure project ticket, as they call it, in the High Court would produce a material benefit, but could in fact increase delays. Chancery Lane went on. Why not reconsider how the protocols are adopted and deployed in particular cases, and look at modifications to the protocols, strengthening the duty of candor to further enable full engagement with the pre-action protocol itself, and try to encourage settlement of issues. That would be another thing that they suggest. So they have a number of concerns. And of course, the organization that everyone thinks of with judicial reviews of public bodies is the Good Law Project.
Yeah.
I don't know whether you spotted that some of their people had strong things to say about the government's plans.
Indeed. And I think it was Joe Morm, I think that's how it's pronounced.
That's it.
Sorry, the executive director of the Good Law Project said that they might make a good story, but there's no real substance to these changes, and are all blocking an appeal against the dismissal of a, quote, meritless judicial review already exists. It can be found in the Civil Procedure Rule 54:12 subsection 7. So I know back in 2020 we pulled the statistics in relation to successful judicial reviews, and they were like very, very low indeed. The actual, and in fact, quite a lot of judicial reviews at that point were struck out at the permission stage. I don't know, Dennis. I don't. It'll be interesting actually to see the passage of this and what the House of Lords make of it.
Indeed, indeed. And another commentator, Lee Marsons, also of the Public Law Project, said that rather impose barriers on the access to justice, which I think fairly that is a fair point. A better solution would be for the Labour government to provide the courts with the resources they need to speedily decide cases. I tend to agree with that view, frankly. What do you think?
Yeah, I mean, it's look, none of this is easy, is it, in relation to what you can see why the government, in terms of its great bold agenda, we've got devolution, it wants to implement growth, it's got some real serious progress elements that it wants to build into the nation moving forward in terms of infrastructure. So it's trying to do something, isn't it? It thinks move it along.
To be fair, it sees a problem with the policy of getting growth as fast as possible. And I understand that. But I'm not sure that this is a real problem that cannot be got around in other ways. I've mentioned a number of contradictions with this, and I'm sort of playing devil's advocate with the announcements that have been made. But many will argue that climate change, and I think it's been argued in court cases, imposes a legal duty as well on decision makers to consider these impacts and the impacts on environmental issues generally. And I wonder whether this is a third conflict inherent in these proposals coming forward from a government that is committed to climate change initiatives and committed to achieving net zero targets. Is that another conflict, do you think, that others will recognise in all of this?
Well, I think it is a potential conflict, Dennis, and we've seen quite a lot of high-profile, successful cases in Europe in relation to climate change and challenges against the government. So that is something to be put into the consideration. That, and of course, when you're curtailing any kind of rights that have formerly existed, one really needs to consider the disproportionate effect upon vulnerable groups.
Indeed, yes.
Who rely on judicial review to challenge decisions that ultimately could impact their rights and their well-being. Yeah,
I mean, I've concentrated, I suppose, on climate change and environmental issues, but we've also seen the active use of JR in our sector in relation to service changes, reductions in service, closures of local community facilities. Much loved and much relied upon community services have gone from all of our areas across the country over the last 14 years. That was a major area where JR was brought into play. Do you think that might change now?
Who knows? I mean, at the moment, that is not what the government's saying. It seems to be restricting this to major infrastructure projects. How it defines that in the legislation or any kind of bill, we'll have to see if we get that far, and I'm sure we will. But, could there be creep? Of course.
Yeah, there could be. I think the term is scope creep. If this is good for this type of application, then the idea might be felt to be more broadly applicable, that there can be this oral stage, this oral hearing where a judge decides that something is without merit. A bit like in the criminal cases where a summary court can decide whether a case should go forward to a high court. The principle could potentially be looked at as to be used elsewhere. This is the problem, I think, as well.
Well, no doubt. I think we'll definitely have to come back and revisit this
indeed
when we see more. But interesting discussion. Thanks for joining me today, Dennis.
Nice to speak to you once again, as ever.